Good afternoon, and welcome to the Society for the Rule of Law's webinar on legal ethics and the rule of law. I am excited to see so many people here today, and this is a great conversation that is also very timely. Legal ethics is a concern today, not just for the legal profession, but it's truly implicated in a lot of the major policy and political conversations we're having in America at the moment. My name is Greg Nunziata. I am the Executive Director of the Society for the Rule of Law. If you are not familiar with us, the Society is an organization of conservative, libertarian, and center-right lawyers who prioritize the defense of the rule of law, the Constitution, and American democracy over our policy or partisan preferences. We are a membership organization, so our members make all of our programming possible. If you are not already a member, I encourage you to become one. We will have a link in the chat where you can sign up. You do not need to be a lawyer to join. We very much welcome everyone. If you are a member, please consider sharing this invitation with your friends and colleagues. I want to give you a few updates and background before we get started today on what we've been up to. We just concluded our annual meeting, our Rule of Law Summit, which happened here in DC at the Four Seasons a couple of weeks ago. All of our programming is open to the public and has been videotaped, so you can watch the entire summit on demand. I think there are 7 or 8 panels. It was a really excellent discussion. We were pleased to have a sold-out, crowded room here in Washington, and we're happy to bring that programming to many more people via video online. We will be having our next event, will be a joint event with Principles First, held in San Francisco on December 4th. I will be speaking there, as well as Jay Nordlinger, formerly of National Review, among others, on law and leadership. We have been active in the press. You can find several links we'll drop in the chats of some of our interviews and essays on matters of public controversy and legal interest. Recently, speaking of public controversy of legal interest, today the Supreme Court is considering the legality of the president's tariffs, and the Society for the Rule of Law Institute was pleased to join with Americans Advancing Freedom and several other groups making the argument that those tariffs are in fact illegal. Our charter member, Professor Ilya Somin of George Mason Scalia Law, is a counsel of record in the case and has been active in it from the beginning. If you are interested, you could watch a webinar we did with Professor Somin just a few weeks ago. We will drop a link to the chat in the chat as well. With that, I would love to move on to our panel. Allow me to introduce 2 terrific panelists. Paul Rosenzweig is a charter member of the Society for the Rule of Law. He's one of the nation's leading experts on cybersecurity and homeland security, and previously served in all 3 branches of government, including as the very first Deputy Assistant Secretary for Policy at the Department of Homeland Security in the George W. Bush administration. He is a senior editor of the Journal of National Security Law and Policy, and a member of the advisory committee on the ABA Standing Committee on Law and National Security. He also serves, importantly to this conversation, as a hearing committee chair for the DC Board of Professional Responsibility. Paul's writings appear widely, and you may have read him in The Atlantic, among other publications. He has a recent article just a few days ago in The Bulwark titled Big Laws, Big Choice. Perhaps we'll get a chance to talk about that later today. A link to that will be in the chat as well. And then I'd like to introduce Miriam Rosenbaum. Miriam is a senior fellow at the Brennan Center, where she works on litigation and policy issues related to federalism, checks and balances, with a focus on the Supreme Court. Previously, she worked at a litigator at a leading Manhattan law firm. She holds a bachelor's degree in public policy from Princeton, where she graduated with highest honors, earned a master's degree in social policy at Oxford as a Rhodes Scholar, and a JD at Yale Law School. She also clerked on the Second Circuit, and she is a co-author of the recent Brennan Center paper, Legal Ethics and the Rule of Law. With that, I'd like to ask our very gifted and talented panelists to take the stage, and we'll start with Paul for some opening remarks, please. Paul.
Great. Well, first off, thanks, Greg, for having me and for putting this together. And thanks to the Society of the Rule of Law for hosting us and frankly, for existing and giving at least me a place to hang my intellectual hat with with some degree of intellectual consistency. I'm delighted that we are doing programming like this. So the context for today's discussion is obviously relatively political in nature. The gravamen of the discussion today stems from ethics charges that have been brought against some of President Trump's lawyers in the wake of the 2020 election. As a result of those, Rudy Giuliani has been disbarred. John Eastman, his California lawyer, has been recommended for disbarment, and his case is pending before the California Supreme Court. Jeffrey Clark, who worked at the Department of Justice for President Trump in the first term, has also been recommended for disbarment in the District of Columbia, and his case is pending before the District of Columbia Court of Appeals, which is the highest court for the district. And it's not just famous names like those. There are, for example, ethics proceedings ongoing against 3 other lawyers in the District of Columbia for making false statements to the courts in connection with Trump's election appeals. Their cases are still pending before a hearing committee, which has yet to issue a report and recommendation. And perhaps we'll talk a little bit more about how that process actually works in more detail later. So what I thought I would start by introducing this topic is to briefly outline what the rules of professional conduct are, how they fit into the broader picture, how we decide what ethics law applies, and then what's happening kind of today before throwing it over to Miriam, who's got a lot more to say about what's happening today. So I want to do a little scene setting for the discussion. Legal ethics is a bit of a misnomer, since ethics kind of always seems to be taken to refer to things like what is morally right or appropriate. And that's important to lawyers. But when we talk about legal ethics in the context of enforceable norms, we're really talking about something called the rules of professional conduct. And they vary from state to state. There's a model set of rules that the American Bar Association has adopted, but the rules in New York are different from the rules in Washington, D.C., and which are different from the rules in Florida. Not a lot, but each has its own variations. Substantively, though, they usually have very much similarities, and they involve requirements for lawyers' conduct that probably most people would find unsurprising. For example, there's a rule about candor to the tribunal, which essentially is code for don't lie to the courts. There's a rule about representing your client zealously, called the rule of zealous advocacy, which is basically code for don't forget to file your client's paperwork and don't forget to represent him in front of the tribunal and meet all your timely deadlines. There's other requirements like put your fee agreement in writing so that everybody knows how much you're going to be paid, that sort of thing. These rules are the product of something that is relatively unique to lawyers, which is that most bars are self-governing bars. We monitor ourselves. The ethics process, the rules of professional conduct, are adopted by the courts and enforced by lawyers against other lawyers. And the challenge for them in today's day is whether or not the pre-existing set of rules that have been around for 30, 40, 50 years in most states are a set of neutral principles that should be applied to all lawyers equally, or are a set of rules that are subject to weaponization, if you will. In many ways, then this discussion about rules of ethics mirrors the discussion about the application of criminal law under the Biden administration versus under the Trump administration, where somebody who supports President Biden's efforts would say he was neutrally applying the laws to President Trump. Former President Trump, others would say he was weaponizing the rule of law. And conversely, today, people might say that Trump is weaponizing the rule of criminal law against Jim Comey, Letitia James, and a whole host of other people. What's at the core, I think, of the discussion today is what I think is fundamentally a conservative principle, which is that there are pre-existing rules. Law is an independent domain that isn't just politics, and that we can apply it fairly, neutrally, without malice, in ways that people who are fair-minded would reflect is an accurate application of the pre-existing set of rules. So, whose law applies? Briefly, the law applies where a lawyer is a bar member. So, I'm a member of the District of Columbia Bar. I am subject to the District of Columbia's bar rules of professional conduct wherever I go. But they also apply in whatever jurisdiction a lawyer is practicing. So when I appear, as I have in the past, in the courts, in the federal district courts of New York, I'm subject to the rules of professional conduct that have been adopted by the courts of New York, the federal courts of New York, which are typically the New York state rules. So, for example, if you're a Florida lawyer and you appear in, say, the Eastern District of Virginia, you would then be subject both to the Florida rules, because that's where your license is from, and to the rules of the Eastern District of Virginia, which has incorporated the Virginia bar rules by reference. And there's this concept of reciprocity as well. So if I am suspended from practice in front of by the Virginia bar, my bar in DC is expected to impose reciprocal discipline on me. So what are the basics of the problems that are facing us today? And this is where I will transition to Miriam. There are three particular rules that are of some relevance today. One I've already mentioned is the requirement of candor to the tribunal. You can't lie about the facts. You can't deliberately lie about the law. And that's the provision of law that has been used most notably with some of the famous cases I started this discussion with. There are also rules about the special obligations of government lawyers, and in particular prosecutors, not to bring cases that they know are unfounded. And that requirement resonates a little bit with some of what we see in the operation of President Trump's Department of Justice today. And that hasn't been adjudicated in any way, but you can see the potential resonance ahead of you. And then finally, there are laws about conflicts of interest, which are rules that require lawyers to represent their client and only their client, and not let their own personal or financial interests influence what they do for their client. And you can see the possible application of that in the article that Greg mentioned earlier, in some of the conduct of big law firms in both settling with President Trump and trying to represent their clients against President Trump at the same time. And you can see how that conflict might arise. And we can tease those out a bit more. But in the end, the question today for us to discuss is, how do the rules of professional conduct, the rules of the legal ethics, apply in this highly politicized legal environment in which we work? Are they, in fact, still neutral rules that can be applied fairly and evenly to everybody, or are they too at risk of being politicized? And with that, I think I've gone about 10 minutes, and it's free for you, Miriam.
Thank you, Paul. I want to start off by saying how thrilled I am to be on this panel with Paul and Greg today. I'm a longtime admirer of the Society for Rule of Law and of Paul and Greg's work individually. I attended the summit a few weeks ago, and the panels were incredible. I learned so much, and I also really enjoyed meeting other SRL members during breaks and meals. So thank you, Greg and Paul, for having me join you today. I agree with everything that Paul said, and I want to add that my interest in legal ethics is stemming from a lot of the discussions that I have with lawyers about current events and how it revolves around what discipline is there as an avenue to put checks on lawyers right now and who might be abusing their power. And I think that the conversation should move away from what discipline can these lawyers face to what norms and expectations should the profession have and should the public have to place as a check on these lawyers. And with that interest in mind, my colleagues and I at the Brennan Center recently published a paper on legal ethics and the rule of law. And our goal was to emphasize that lawyers, particularly government lawyers, are bound by ethical rules and standards, even when other checks, like discipline, fail. So our goal is to elevate these principles in the public consciousness, because by making these principles visible and widely understood, we can create a common understanding among judges, the media, policymakers, and the broader public as to what lawyers are and are not permitted to do. And so in writing this paper, we identified 6 non-negotiable principles and obligations. And we did this by drawing from constitutional and statutory law, from rules of civil and criminal procedure, and from soft law, including codes of professional conduct, which Paul explained, longstanding DOJ policies, and other agency guidance. And we workshopped these obligations and principles with dozens of legal ethicists and practitioners, including government lawyers, big law litigators, law school professors and deans, and former federal and state judges. And our goal is to learn how to talk about these principles in a way that sets the expectation that, of course, lawyers follow these principles, both in private practice and in the government. So I'd like to run through these 6 principles with a few current and historical examples of how they might play out. The first principle is that honesty is mandatory. So dishonesty can take many forms: misrepresenting facts, omitting details, or misleading courts, clients, or the public. And the duty of honesty for lawyers sometimes even applies beyond the courtroom. So some recent famous examples include Bill Clinton, who was disbarred in 2001 for giving misleading testimony under oath, and 2 lawyers in 2012, Joseph Bottini and James Goke, were disbarred for withholding exculpatory evidence during the prosecution of Senator Ted Stevens. More recent examples include the ones that Paul referenced, related to statements about the 2020 elections. Another example that I find really interesting involved dishonesty outside of the courtroom. In 2014, the California bar refused to admit a lawyer, well, not a lawyer, someone who went to law school, named Stephen Glass, because when he was a journalist, he fabricated at least 40 articles in the New Republic. And the Supreme Court of California issued an opinion underscoring that sustained dishonesty, even outside of the courtroom, in some circumstances, can be incompatible with the legal profession. The second principle I'd like to highlight is that court orders must be respected. Disobeying or encouraging others to defy court orders violates many disciplinary rules and also risks contempt sanctions. The third principle I'd like to highlight is that criminal investigations, prosecutions, and lawsuits must have some good faith, credible basis in law and fact. Criminal prosecutions require probable cause, and civil actions must be legally and factually grounded. The threshold for discipline in civil cases is high, but novelty does not excuse groundlessness. I'd like to highlight 2 recent examples of government attorneys who faced pressure to violate this principle. The first is Denise Chung, who was a senior government attorney and resigned in 2025 after refusing an interim U.S. attorney's order to open a criminal probe and freeze green energy grant funds without sufficient evidence. Additionally, Eric Sieber, who was the U.S. Attorney for the Eastern District of Virginia, resigned in September 2025 after he resisted bringing charges against New York Attorney General Letitia James due to his opinion that there was a lack of evidence. The fourth principle I'd like to highlight is that law enforcement cannot be used to harass, intimidate, or exact political retribution or as leverage to achieve unrelated political goals. A recent prominent example of a lawyer resisting to violate this ethical requirement is the case of Danielle Sassoon, who used to be the acting U.S. Attorney of the Southern District of New York. And she resigned in 2025 because she was getting pressure for her office to dismiss the federal corruption case against Eric Adams. And she said in her resignation letter that she could not in good faith seek dismissal because the law did not support it. And she was confident that Adams had committed the charged crimes, and she believed the directive amounted to political quid pro quo. Quid pro quo. Sorry about that. And I'd like to say something that I hope isn't too controversial. A lot of the conversation about government lawyers quitting uses language like heroism and puts these lawyers on a pedestal that they've done something that is so above and beyond what a regular lawyer would do. And the conversation is about how bad Ed Martin and Eric Adams are and how amazing these government lawyers are. And I'm sure that they are amazing and are good people. But I'd like to take the language away from heroism and more into obligation and expectations, because these lawyers who resisted and quit tried every other avenue and had no other recourse to avoid violating their professional responsibilities. The fifth principle that I'd like to highlight is that conflicts of interest and similar misuses of office are generally prohibited. Paul highlighted one really interesting example now of a potential conflict of interest, which perhaps we'll talk about more later. I'd like to highlight another interesting example of a potential conflict of interest going on right now. So it involves a potential DOJ settlement with President Trump, who submitted 2 administrative claims recently to the DOJ, seeking $230 million in damages. Ironically, both of his claims are based on his belief that law enforcement was weaponized against him. What's interesting to me is that when there is a DOJ settlement, which there might be in this case, any settlement of more than $4 million must be approved by senior DOJ officials. And some of the senior DOJ officials who would approve the settlement previously served as Trump's personal lawyers or represented his associates. And so this to me is a very concerning conflict of interest, and we'll see how it plays out. The sixth and final principle that I'd like to highlight is that lawyers are responsible for their own conduct and that of their supervisees. So lawyers can't deflect responsibility by citing orders from superiors, and conversely, leaders are accountable for unethical behavior that they authorize. And my hope is that by talking about these principles as an expectation, we can just make it a norm that, yes, this is what's expected by lawyers, whether they're in private practice or in government. And now I'm really excited and interested to hear Paul's take on some of the questions he raised in his opening remarks about politicized use of the disciplinary process.
Thank you, Miriam, and thank you, Paul. That was a really great introduction to all of this. And I want to just say to everybody in the audience, I'm going to start this conversation between the three of us now, but we're happy to take questions from all of you. And the way to submit questions is to just enter them into the chat, and I will pose them to our panelists as they come in and as we have the opportunity to. You don't need to wait. As things occur to you, please just drop it in the chat, and I will get to it as soon as I can. So before I even started, saw a question, somebody asking if they could get the Brennan Center report that Miriam just discussed. Yes, it should already be at the top of the chat, but we can drop it in there again. It is online. If you just Google Brennan Center and ethics, you should find it. It's a great report, I want to say, Miriam. It's very readable and it's accessible to non-lawyers. It's organized with bullet points, so if you just want to skim for the highlights, you can do that. But it has footnotes if you want to go deep. So it's really accessible to a wide range of audiences, as was your presentation and as was Paul's. I think most of us who are lawyers will remember a lot of these big concepts from law school, but maybe we haven't thought about them in a while. And hopefully those of us who are lawyers have not had to deal with the nuts and bolts of ethical charges and professional responsibility proceedings. So Paul, can you maybe start us by just giving us an idea of like what this means? If you are, how does one become accused of violating their professional responsibility, and how are those accusations resolved? What does the process look like? Should we trust it?
Sure. So, with the caveat that every state is slightly different, I'll tell you how it works in DC, and then compare that to California. And then, Florida's a little different. Nevada's even more. But in the District of Columbia, complaints about lawyers are received and reviewed by something known as the Office of Disciplinary Counsel. You can think of them as sort of the ethics investigation and prosecution unit, if you will. So they have a public-facing website. They hear from clients of all sorts, ranging from, my lawyer didn't file my case on time, to formal complaints received from congressmen that certain lawyers acted unethically in appearing in front of them or in exercising their official duties. The Office of the Disciplinary Counsel investigates these allegations, often seeking response from the lawyer who is the subject of the complaint as part of their investigative process. And if they conclude that there's nothing to it, that they cannot establish a violation by clear and convincing evidence, which is the standard that they use, then they'll wind up, saying, okay, everything's done, we're gone. But if they think that there is evidence of misconduct, a violation of one of the rules, they'll file what's known as a specification of charges, which is essentially a charging document. You can think of it either as a complaint or as an indictment, depending upon whether you want to think of this as civil or criminal, which says, Paul Rosenzweig violated 3.3a in that he lied to the court on thus and such a day about thus and such a thing. And I get to file an answer or response. And then the contested proceeding is heard in front of a hearing commission. I am a hearing commissioner with the Board of Professional Responsibility. And that's a 3-person panel, 2 lawyers and one private citizen. And we take evidence. Well, think of it as kind of like a magistrate judge or a district court judge. I did a proceeding in March of this past year that was 4 full days of testimony and, over 700 different exhibits. That was larger than normal, but that was pretty large. Then the hearing committee files what's called a report and recommendation, where we make findings of fact, recommend conclusions of law, and recommend a sanction. So we might say, yes, we find as a factual matter that Paul lied about A, B, and C. We conclude as a matter of law that violates Rule 3.3a, and we recommend that he be sanctioned by being suspended from the practice of law for 3 months. That recommendation in turn goes to something called the Board of Professional Responsibility, who are the actual disciplinary body appointed by the court, and they'll accept the report, modify it, reject it sometimes, though hopefully that's rare. Hopefully we do our jobs well. And ultimately, if the affected lawyer, me, doesn't like what the board does, I can appeal to the District of Columbia Court of Appeals. So that, for example, is what has happened exactly to Jeffrey Clark. The board has imposed discipline and recommended his disbarment, and he's awaiting the Court of Appeals' determination of his contention that they were wrong. California is slightly different. They have a judge process at the fact-finding level, then a 3-judge appeal process, and then the Supreme Court of California hears the final appeal. But it's essentially the same process through 3 levels. Some other areas do only 2 levels, a finder of fact and then an appeal to the court. But essentially, every one of them has the same 3 things: an investigative/prosecutive office, a factual and legal determination, and then an ultimate level of appeal, which is the court of last resort in the state in which your license is being challenged.
Thanks, Paul. Miriam, Paul mentioned Jeff Clark a couple of times, and I know certainly a lot of the president's allies and maybe some others have raised questions about whether the ethical claims, charges brought against Mr. Clark and many of the other figures connected to the president, Rudy Giuliani, whether these charges were politically motivated. Sometimes they say, well, look, lawyers have another duty of zealous advocacy, right? And lawyers are supposed to make aggressively any plausible argument they can make. And these folks will say that Mr. Clark, Mr. Giuliani, maybe others have been punished for doing their duty of zealous advocacy and trying their best to represent the president's arguments that he ought to remain in office or whatever it might have been. So how do we think about these 2 factors? What is zealous advocacy and what is overreaching worthy of sanction?
That's a really good question. And I think that the fear of being punished for zealous advocacy, I can't think of any examples in history or recent events where someone was actually punished for zealous advocacy, because the laws of professional responsibility require you to zealously advocate for your client, and they're built in a way that helps you do that. And punishment for going over the line and crossing the line is such a high bar. So I think about this in terms of free speech for lawyers. I think that there are very clear cases where lawyers don't have free speech to just say whatever they want because it does violate rules. So a very clear case would be if I, as a lawyer barred in New York, went to Wyoming and told everyone there I was licensed in Wyoming and familiar with Wyoming law and could properly advocate for them in court. That would be malpractice in the same way that a doctor doesn't have free speech to give a patient bad medical advice and then say, oh, I don't have any responsibility after the patient takes that advice. I think that the grayer cases that people are nervous about involve questions of dishonesty as opposed to opinion. And there, the Supreme Court in 1991 said that there is a very, very high bar to cross that line. So I think the case was Gentile versus the state of Nevada. There was a lawyer, a defense lawyer, who made statements outside of the courtroom to the media about his client's case. The Nevada State Bar said that this violated professional norms related to extrajudicial statements. And the Supreme Court said that lawyers do have free speech, but it's limited in cases that could materially affect the outcome of the trial. And also they have to be made knowingly or with very gross negligence. So to reach that bar is really high. And in fact, in that case, the Supreme Court said that the defense lawyer at issue did not violate his professional norms. I think the case of Eastman is a really interesting one because if we actually look at the facts, it's very clear that he knowingly made statements which were false. And so I think that this fear of courts punishing lawyers for zealous advocacy doesn't really happen in practice.
And Miriam, in the Eastman case or in general, is there a difference between statements that are false, statements of law that are false, or statements of fact that are false, or is it all the same?
I think that the questions that the court focused on is whether his statements of fact were knowingly false, and they had enough evidence to say that he knew what he was saying was false regarding the behavior of election officials, and it would be a very high threshold to find that, which they did.
So Paul and co-counsel,
sorry,
it's all right. Assuming that, granting that the rules are reasonably clear and the standards are reasonable, as Miriam laid out, and that the mechanisms that you described work pretty well, is there any reason to still be worried about maybe the proliferation of professional responsibility or ethics complaints brought against people in public service? If they become routine, is fighting off even claims that lack merit a real burden or disincentive to serving in government?
Well, I think that what you are asking is almost a recapitulation of why the Society for the Rule of Law exists in a way, which is to say that up until today, I have seen no real evidence of the systematic weaponization of the ethics process. I worked for Ken Starr during the investigation of Bill Clinton, and I actually got my start doing ethics at defending him against complaints that were filed with the Office of the Disciplinary Counsel, then known as the Bar Council, by Clinton and Clinton supporters, alleging violations of our ethical obligations under Rule 3.AE that has special requirements for prosecutors. My perception then was that those complaints were ill-founded and meant to weaponize the process. But my perception was that they were also well treated by the process, which is that with the application of time and effort, and yes, that's a cost and a distraction, they were appropriately dealt with by the systems at the time. And I think I would say the same today about complaints involving the Trump supporters. There have been, for example, complaints about Ed Martin, who we've mentioned already, that the Office of the Disciplinary Counsel in D.C. has, I won't say dismissed out of hand because I don't know their process, but has reviewed and dismissed and said, we're not going to bring ethics charges of any sort on that basis, which says to me that a well-meaning, good faith, functioning ethics process exists and can be relied upon. That having been said, the ethics process is no more immune to capture and misuse than the Department of Justice is. And perhaps it is more immune because there are 50 of them. And so you have to capture the ones where the people who are your targets are licensed to practice. And, that could be more difficult. But it would be foolish to not acknowledge that the last few years have seen norms of good faith application of neutral law eroded. And I couldn't possibly tell you that that won't happen in the ethics disciplinary domain as well. On the other hand, I think it's that if we take counsel of that fear, if we refrain from applying the ethics rules as they currently exist because of our fear that they'll be misused sometime down the road, we're making a mistake and condemning ourselves even before the first shots are surrendering, even before the first shots are fired. So the answer is, yeah, it's possible. It hasn't been in the past, I don't think. I would stand by that as an accurate factual statement. And hopefully we can do better in the future and not see it devolve into that.
Great. And please, to our audience members, feel free to keep submitting questions, and I'll continue to weave them into our conversation today. Miriam, can you just talk a little bit about what the role of judges is here, whether both on their own ethical obligations for what ethics rules apply to judges, but also how they can think about applying the rules of ethics and how they oversee investigations or proceedings before them?
That's a really good question. Judges are bound by the rules of legal ethics, and they even have their own codes of conduct, which primarily focus on being impartial and appearance of impartiality. When it comes to checking other lawyers who might be abusing their power, I don't think that judges have full control to stop it, but they have a lot of mechanisms along the way and at the end of cases. So I think along the way, they can focus on reining in bad behavior through review of warrants and subpoenas and pretrial motions. So even now, both Comey and James have motions to dismiss pending that are based on a claim of an argument saying that there is selective and vindictive prosecution, and the judges get to review that. I also think that when it comes to government lawyers, judges can take away the presumption of regularity when they think that a government lawyer is not acting honestly or ethically. And I think at the end of the case, the judge can take a government's bad behavior into account for the ruling, and can also try to correct any wrong that motivated bringing a bad investigation or a bad prosecution. So a recent example of this, I think, is with Judge Ho, when he dropped the Eric Adams charges with prejudice, because This relates back to the example of Danielle Sassoon that I mentioned during my opening remarks. Eric Adams had charges brought against him. The government wanted to drop them without prejudice, meaning that they could bring the charges again whenever they wanted. And it seemed from internal memos and questioning of government lawyers that the motivation there was to be able to have leverage over Adams' behavior if he knew that these charges could always be brought again. And the judge maybe couldn't stop this behavior along the way of the litigation, but at the end of the litigation, he was able to say, I've reviewed all the evidence. I've heard the government's arguments. There is no reason that the case should be left open for charges to be brought again. And he dropped the charges with prejudice. So I do think that judges don't have all the power to stop unethical investigations and charges, but they do have a lot of power.
That's excellent. You mentioned during that answer, Comey and James, the prosecutions that are ongoing now, that many of us, anyway, in the Society for the Rule of Law, I know I do, perceive as problematic and politically motivated, to put it gently. Sometimes I'll hear folks say, well, let's just see the system play out. If they're guilty of something, they're guilty of something. Which leads me to a question. There's a well-known legal writer named Harvey Silvergate who wrote a book several years ago called 3 Felonies a Day. And the idea was that the federal criminal law is vast and sometimes vague, and a really deliberate prosecutor could probably pin a felony on any American. We know from this conversation that a lawyer cannot ethically bring a prosecution that has no basis in fact. But can a lawyer ethically identify a target and doggedly try to find something they've done to prosecute them? Is there an ethical problem with just kind of the motivation, even if there is a legal foundation for a case that are brought? And or is that a problem that needs to be addressed outside of this framework?
I think there's definitely many ethical issues with doing that. Selective prosecution and vindictive prosecution is not allowed. DOJ guidance talks about that. The rules of professional responsibility talk about that. There's protections in constitutional law and in statutory law, in civil law and in criminal law. And we do give prosecutors a lot of choice in what they bring. And I think that's a good thing, which we could talk about as well. But just because they have a lot of independence in choosing who to prosecute, they can't look at two people who have done the same exact thing and have a politically or personally motivated reason for bringing the charge against one person and not the other.
Paul, do you want to comment on that directly? Otherwise, I have a follow-up.
I think that's an accurate statement of the rules, which is to say it is unethical to target somebody for invidious reasons. The obvious caveat is that it's perfectly appropriate to target somebody for what's the opposite of vidious reasons, I guess. The classic cases like John Gotti or Al Capone, where the prosecutor is in fact picking the target, and they'll find whatever it is, tax fraud for Capone, right? Parking tickets for Gotti, for all, but it is a special set of responsibilities not to engage in behavior that is based upon inappropriate or unreasonable definition. You can't say I'm going to prosecute all the black people in New York, or all my political opponents. It is, in fact, to my mind, at least plausible that at the end of the day, some of the people who are bringing these cases at Mr. Trump's behest will themselves face questions about their behavior before the disciplinary authorities who oversee their licenses or before whom, or in jurisdictions where they have appeared. You can't front run that too much because we're still developing the facts, and the courts haven't made determinations about selectiveness or vindictiveness. But the public facts that we know certainly suggest that some of what some of these lawyers is doing may have been motivated by for reasons that are not appropriate for consideration.
Paul, I want to ask you just a question about the politicization of the Justice Department that deeply concerns me. Many of the commentators who see what's going on now really talk about this as threats to the independence of the Justice Department. They say DOJ must be independent from the president and his agenda. I think conservatives have always resisted that kind of phrasing. Conservatives who may believe strongly in the unitary executive, and even as a legal matter, and even apart from a legal matter, have practical concerns with an idea that prosecutors would be truly independent from political control. There are downsides to that too. So I guess I'd just like to ask you to comment on that broadly and consider whether legal ethics and a meaningful application of the rules of professional responsibility actually gets at all the concerns people have when they say they want an independent Justice Department.
That's a great set of questions. So I would answer it in two parts. The first part about the independence of the Department of Justice is, I stand with most of the other conservatives as having been for a long time not comfortable with the complete independence of a prosecutorial unit. But I had always thought of it as the president's authority and indeed obligation to set priorities, to say we're going to prosecute drug crimes and not prosecute gun offenses, because I'm a Republican and that's what I believe. And for Janet Reno to come in and say we're going to really go after wife abusers who have guns, I mean, that's the type of thing that at a systemic level, I think is what we mean to get at. It strikes me as crossing some line that is very difficult to define when it's please go and bring charges against Jim Comey for lying before the statute of limitations passes. And the fact that I can't readily draw that line at a high level of generality makes me a little worried about my belief in the unitary executive theory, honestly. But I don't think too much, because I had always believed in it when conjoined with, and this gets to the second part of your question, effective controlling norms of behavior, that the president could do much in the way of direction, but as a matter of practice, President Biden was not going to tell Merrick Garland, go after Donald Trump. And as a matter of practice, President Clinton did not tell Janet Reno, don't go after me. We had presidents who exercised restraint. In the absence of that, do legal ethics constrain behavior? Yes, but I think inadequately, which is to say that even though, for example, we just talked about the possibility that the prosecutor who has brought charges against Comey and Letitia James may in the end find herself in front of a disciplinary authority, the rules of professional conduct, the ethical obligations there are, as Miriam said in the opening, less about punishment and more about norms of behavior that we hope lawyers will internalize. And it seems to me clear that we can't rely on that completely as well. What we really need, what is essential, is an educative process that hopefully teaches us all to be Danielle Sassoons and not to be subservient to inappropriate importunings to act in ways that don't really fit the rule of law. So the answer is yes, it's going to help some. I think the fact that some of Trump's lawyers have been lost their licenses or may lose their licenses for what happened in 2020, restrain some actions in 2024 and maybe in 26 and 28, but it's an imperfect way of proceeding.
Over the last several years, there's been a lot of dismissiveness about just the word norms and the notion of norms, and the longer we get into this, kind of the more I think norms are the most important thing out there, defending the values that we share. Miriam, I have a question in the chat, which I think is a good one, and it's from someone in the healthcare industry, and he or she says that in that industry they have the perception that there's a cultural discouragement against filing complaints against colleagues, and there's a feeling that it could hurt your career to do so. Is the legal industry like that? And more broadly, can we trust lawyers to police themselves? I mean, is there a concern there?
That's a great question. And it's something I think about a lot. And that's one of my motivations for wanting to write and talk about why discipline can't be the only check on attorney behavior. The reason you mentioned is a very good one. The disciplinary process also takes years to reach completion sometimes. Paul could talk more about that. And also the disciplinary process is reactive to bad things that have already happened. And so for the reason you mentioned and some other reasons, we can't rely on the disciplinary process as the only check on lawyers. And this is why I think that having other checks like courts step in, whether it's through sanctions or getting rid of presumption of regularity, and most of all by the profession and the public stressing that there are certain expectations, that is in a way an even more important check. And that can show up in a number of ways that are mechanisms of lawyers checking each other without filing discipline. So hiring people to represent you personally, or a company choosing which law firm they're going to hire based on their reputation. Deans deciding which law professors they're going to hire or choose to speak to their students. There's a lot of soft power ways that lawyers can hold other lawyers to account short of filing a disciplinary complaint. And I think that those are equally, if not more important checks.
Paul, what would you say today to a young, let's say a young conservative lawyer who's principled and eager to serve her country and considering to go work in this administration, either in a political role or a career role? Maybe the advice is different in each category.
Well, it's a very fraught time right now, in ways that it wasn't when I was in law school. I mean, and it wasn't even for the last 30 years before now. I used to give a talk to people who were thinking about going into public service in which I said, it doesn't really matter which side you choose, whether you're a Democrat or a Republican, because in the end, there's a shared sense of purpose, there's a shared sense of value. Today, I would say that is breaking down, and that there's an increased polarization in which either side is thinking that the other one is not part of the same shared sense of value. And with that as a cautionary note, my advice to a young conservative lawyer or even a young liberal lawyer who is thinking about government service or thinking about entering public life in some way, either as a careerist or as a political, is that you need, I think, to know about that polarization and decide what that means for you. For me, it means I would advocate that you reclaim that sense of shared purpose, the realization that you can disagree without being disagreeable. You can have different views of legal, of what the right policy is in New York City without being unethical about it and without lying to the court or that. And so I would urge them to reclaim that and not be seduced by the sense of polarization that is infecting the profession, because honestly, in the end, if the profession can't get past that, if it becomes as polarized as the political domain is, then our entire claim to self-regulation and to law being a separate domain from politics evaporates completely. And then judges' decisions are just political decisions through a different mechanism. And I refuse to believe that. In my core, going back to my first days at law school, I was taught that law had more to it than that. And I believe that to my very being. And I would encourage them to believe that in their very being. But if they don't believe it, if they really have given up on that, then I would say get out of the practice of law and go do something else. Because that's not the way to do this profession. I hope.
That's fantastic. And I think it's worth noting for those who might not be aware that some of the names that Miriam mentioned of folks who resigned on principle and on their understanding of their ethical obligations over the last several months have been well-known conservative lawyers, and this is not a left or right axis we're on right now, but we're talking about ethics in the legal profession. I have many more questions, but we're also running towards the end, so I'll give both Miriam and Paul one more turn at the microphone to either offer some closing remarks or maybe raise at some point that we haven't gotten to or that you would have liked to talk about. Miriam.
I just want to elevate one thing you just said, that legal ethics are not partisan. And the only way that a professional norm can remain as a norm is if it's acted upon. And a lot of conversations I hear with people of different political leanings will only look at what the other party has done wrong. And historically, we can all agree that there have been examples of lawyers who haven't acted their best in both political parties. And I would just urge people to remember that this isn't a partisan issue and that we have to keep allies in both parties held to account.
Thank you.
So in the comments, there's a note from a person known as Space Kitten. He says, we reside in a judicial oligarchy at this point. Constitutional republic no longer exists. And he says both in California and in Texas. My last message is don't despair. There is more to law than that. If we believe that, if we think that Space Kitten is right, fight it. If we think he's wrong, explain why. But either way, legal ethics are at least a part of the solution. The solution is much broader than that. It's at the polls, it's in the court, it's in who we choose as judges, all that. But in my narrow domain, don't despair.
Thank you so much, Paul, and thank you for setting me up for closing that. We share these values here at the Society for the Rule of Law, that law is a thing, it's a knowable thing, it's a meaningful thing that we commit to together. It's a framework for resolving our differences or learning to live together when we can't resolve them. It is a system of fair play as best as we could approximate on this earth, and it's so important that none of us give up hope in that none of us choose just combat and our own side over that kind of framework that allows us all to prosper as Americans. If you agree, please consider joining the Society for the Rule of Law. We are a membership organization. The support of our members made this event today possible, and all of our programming, our education, our symposia, our debates about these issues, as well as our advocacy in the public square for these principles that are so important to who we are as Americans. Thank you for being part of this today. This presentation has been recorded. You could share it with your friends. You could watch it again. You could follow us on YouTube, Twitter, Blue Sky, LinkedIn, and Facebook for the latest from the Society for the Rule of Law and for our future events. Thank you all so much. Thank you, Paul. Thank you, Miriam. And thank you to all of our guests today.
Thank you.
Thank you.